This conference will now be recorded.
We've called the meeting to order at 7 o'clock on the 29th of September. And as usual, the first and strangest item on the agenda is to make sure that everybody is aware of their personal emergency exits. And you will all know where they are and can deal with them appropriately. I would ask anyone on the committee wishing to declare any pecuniary interest in any matters on the agenda to do so now, or wait until we're addressing the particular matter and do it at that particular time. First off, so the general idea is that we'll go through the agenda as it's been laid out, but first we ask any members of the public if they have any more general questions to pose or raise before we adopt the agenda, knowing that you'll have every opportunity to address a particular matter if you've called in about that particular matter of concern to you. Anyone having any comments at this particular point? Seeing none, I'll draw your attention to the meeting agenda. Is there any other business that anyone wishes to add at this particular point? Jerry, Brenda?
No.
No.
And we've had circulated by Susan our minutes from the last meeting. Are there any, well, first I better request a mover for the agenda as it's been circulated.
I'll move it.
I'll second it.
Moved by Brenda, seconded by Jerry. It'll be pretty straightforward this evening with a bare quorum here. So to move on to the minutes from the last meeting, does anyone have any comments on those minutes or requests for any amendments of those minutes? Brenda?
No.
Jerry?
I will move them as adopted as read.
Moved by Jerry, seconded by Brenda. Adopted. So that lets us go on to the first of the agenda items for tonight, which is the application A06-21 by Anthony Bartolini at 1 St. Mark's Crescent with a minor variance to permit a proposed cabana at the rear of the yard that is closer to the side yard than is allowed in the bylaw. Should I, at this particular point, ask you, David, to offer any additional questions on this? I've had a chance to drive by and have a look at it, and the maps and the figures are the figure and the application seem quite straightforward. David.
Thank you, Chair Riley. I appreciate that. They're both applications that, in my view, are actually quite straightforward. But to deal with the first one first, A06-21, it's for a cabana to be in a rear yard area in the Brookfield community area. It's all zoned suburban residential in this area. Now, this one is zoned SRU8. I believe it reflects the fact it was a corner lot, but the provisions under the RU8 are quite similar to the standard RU provisions. It's quite appropriate, minor in my view. The only thing I did notice, and I did speak with the designer, Anthony Bartolini at Square Design, Square Design Group, is there were actually two more variances. And I've noted that in the second chart on page 2. Well, one actually on the first chart because it deals with coverage. And the second one,
This is page 2 of your particular, of your report.
Planning report.
Planning report.
Yes. In both cases, though, the additional variances would be for lot coverage. So they're over a bit, the 33 maximum coverage at 35.8%, really not a lot. And the other one is for the rear yard to the pool equipment, which is about 1 foot and 1 inch, about 0.33 meters. So altogether, there are 3 variances, but collectively, they're all very much, in my view, minor. My report reflects that. I've included what I believe are standard conditions. I've simply added that they get their permits and made that a condition of the variance. The variance would either survive or fail based on that permit, which of course they would need anyway. And just to confirm that the existing works there were done by permit, I'm pretty darn sure they were. I have no reason to believe otherwise, but I just need confirmation of that. The third condition, really, I don't know that the risk management officer would have much to say, but there is a wellhead protection area that goes over part of this property. It's a class B, I believe, wellhead protection area. So not the most sensitive one, but then again, if he would get us an email or clearance letter to this effect, I see no reason why we would not get one. It's a built up area. And as I said in my report, that particular matter would have been most wholesomely dealt with at the time of the subdivision anyway. And of course, a standard fourth condition there regarding any outstanding fees, taxes, and charges of that nature. Straightforward in my view.
Could I just ask for clarification? When I read through it, it looked like the side setback was a major variance, but it's adjacent to town property, and the town doesn't have any objection. When I looked at the setback from the rear fence line, I thought that it, as it was laid out, was within the regulated setback. So it left the full amount of setback with the rear neighbor. Am I not, did I misread that?
Well, perhaps in the chart, the required for rear yard is 0.6 meters. They would provide 0.33 for the pool equipment. So that was not picked up in the application. That's one of the 2 variants that was not picked up in the application. But again, in my view, it's pretty darn minor. And the other one was lot coverage. Although it's in Mr. Bartolini's chart, he just didn't reflect it in the application. So they're there for the view in the plans that were submitted with the application. They just weren't itemized in the actual application write-up form, if you will. So we simply noted that, caught that, and included in this report.
So I'm always sensitive to the neighboring property, and is there any information that you've learned from the rear lot neighbor about whether they have any difficulty with the proximity?
Well, they were circulated. We have had no inquiries to that effect. And so I believe there's a fence around the area already. There has to be for the pool. So the neighbor would have got circulated, and being a budding neighbor absolutely would have got circulated. And if they had had an issue with the car's proposal, we would have heard about it, and we did not. Unless Mr. Bartolini can add further to that, he's online. He can perhaps enlighten us more.
Well, that would be good, because I looked at this figure, and it looked to me like it said it was a setback of 1.04, no, 1.104, something like that.
I
So
got 1 foot 1 inch. I mean, it's impact doesn't go just to measurement. It goes to influence with the context of the lot situation, abutting lot situations.
Yeah.
It's, I've seen some even lesser variances in my time, but it's in the corner, and it's in a fenced yard. It's not as if it's a 3-story, a tree house or something that's going to overlook the abutting property. So I think, in my view, still remains minor.
if Mr. Bartolini's on, perhaps he might might address this at this particular juncture, and I would be interested in knowing how well he gets along with his neighbor.
Well, he's the designer on behalf of the car,
Ah,
but he can speak
Oh,
to the
the
application.
applicant
Mr.
is
Bartolini,
Bartolini. There you go.
can you please answer Chair Riley's question? Thank you.
Hello?
Hello?
Hi there, how you doing?
Very well.
Awesome. Well, thanks for taking the time to look at the application. As mentioned, I am just a designer on the project. I think the neighbors all get along pretty well there. I personally think that, it isn't our intention, I should say, to, have any impact on the neighboring property with the pool equipment there. I do know that I believe their property is set back, so that would actually only be affecting their driveway, if I'm not mistaken. I would need to Google Maps it, but I do believe that property is set back a distance, so that pool equipment would actually only be, if affecting, it would affect, more or less their driveway or entrance area. But I'm actually in the process of just
I can-
looking it up on Google
I can
Maps quickly.
confirm that from the location map that we have.
Sorry, I didn't get that.
Well, I'll ask committee members if they have any questions or comments they'd like to make. Brenda, could I ask you?
I don't have any objections to this minor variance whatsoever. It is very minor, in my opinion.
And Jerry?
I'm of the same opinion. Think we go with with our planner's report. However, like John, I'm always concerned about what the neighbors think, but it doesn't sound like there's been any questions. So I would go with David's report.
Mhm.
Is there anyone from the public who would like to express an opinion or ask any questions about this application A06-21 at this point? Hearing none, I'd ask for a mover for the recommendation as drafted by Mr. Trotman on page 3 of his planning report.
I will move.
Moved by Brenda.
I will second it.
Jerry.
David, stand up.
Uh,
I will second it, yes. But David's got his hand up there.
I think David's got his finger there, perhaps suggesting that it's as amended.
Well,
It's all well. I'm just confirming what Mr. Bartolini said, that in fact, that corner abuts the driveway and buffering lawn of the driveway to the lot to the south. The house to the south is oriented 90 degrees away towards Meek Avenue. So it's, yeah, there's no impact there in my view at all. Just add some clarity to that point.
Very good. Those in favor? Say aye.
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 Aye. Thank you very much, Mr. Bartolini. That matter is approved.
Thank you guys very much. Have yourself a good night.
Thank you. Turning our attention now to application number B04-21 by Christine and Andre Walker. This is a matter of the transfer of approximately 0.6 acres from the neighboring property to the Walkers, who recently purchased the property, determined that their driveway was on an adjacent property, and found and discovered and are acting on a previous commitment to transfer that approximately 0.6 acres to them from the adjacent property owner. So with that said, I'll ask David if he wishes to elaborate on the planning report. Thank you, David.
Thank you, Chair Riley. It's a lot boundary adjustment. the amount of parcel of land that would be severed from the abutting lot and merged is also fairly small in my view. It's to correct, you could call it a technical glitch. It was an oversight, however it occurred with respect to the fence and the driveway. And the only alternate would be through an easement on title, but I think in the balance, the lot boundary adjustment is the cleanest way to deal with this. And that's what they've come forward for. The lawyers have all weighed in on this as well. So I don't have any issue with it. I think it's within keeping and appropriate to the town's official plan requirements. Neither land is prime ag. And quite frankly, even if one or either were the bigger one, the piece from which the land's being severed, it's still pretty darn minor that it wouldn't impact any farming functions, but that's not even the case. It's not prime ag. So
That's right.
the only other thing I noticed was it is in proximity to some natural heritage on the other side of Fourth Line, but there again, it's a woodland. Well, not to diminish the fact it's a woodland, but my point being, it would have no impact on that natural heritage woodland across the road. I consider it quite technical, and I consider it to be appropriate. And I've itemized the normal standard conditions that would or ought to accompany the approval if community so chooses to approve it.
Can I ask committee members for any questions or comments? Brenda?
I don't have any comments or whatever. It looks like it should have been done years ago and failed to get done. So,
Right. Jerry, any comments or questions?
No, I don't have, I agree with Brenda that it probably should have happened a long time ago. The only thing of note was, and David maybe knows this and maybe he doesn't, talks about the transfer of an easement to the township. If there isn't enough road clearance there at this point in time, do you know if that's happened or if it's going to happen when it's surveyed, or what the status of that is? Sorry, I think I lost you, David.
David, if you, there we
I've
go.
to your point, Jerry, that I've known in condition 4, if there were to be a deviation respecting the road allowance, it would convey to the town. I don't think there is. I've looked at the ortho mapping. I don't know if that answers your question, but I mean, I've captured what I think your query is under condition 4.
No, that's fine. I just hope that the landowners would know that if there was going to be a transference to the road allowance, because I have seen before that happens, and then 20 years later, when somebody goes to sell it, why they find out that they actually have to have a survey done and transfer some more of the land to get a road right away. So that's the only thing I noticed.
I don't foresee it, Jerry, but it is captured. I believe your concern inquiry is captured under condition 4.
Could I just
I'm
ask further clarification on that, David? So what you're referring to is that kind of habitual request / requirement of Mono to sever an additional parcel for the adding to the municipal road allowance?
Yeah, and it's that my condition 4, I think will do that. There may
Well,
be a small.
We'll do what? Be specific. Are you requesting and requiring them to transfer land?
Condition unknown at this time, but it's minor technical. If there is to be a small portion of the front of the parcel to be severed
Right.
and emerge
Right. Now,
at the front of the property or the right of way.
what goes into that decision? And because I reviewed in
Sure,
detail
that's a fair
the
question.
25-year, let me just finish my question. That I reviewed the 25-year plan for Mono's roads, and there is no plan in the next 25 years to widen that road. I just want to make it clear, and for the record, that I think this requirement is inappropriate on roads where there are no explicit plans by the municipality to expand the road width.
Yeah, it's not for road widening. It would simply to address minor deviation in the actual road allowance, which would affect or be at the front in a small portion of this parcel to be severed. And if that were to be the case, and we won't find that out if it's even going to exist until we get the draft R plan.
Yes.
If that's
And
the case,
I'm quite willing to leave it up to the applicants to sort that out with the town. So I don't have any additional questions to what Jerry raised, with the one observation that it's remarkable the awesome lot of legal costs that such a straightforward matter seem to require, and and how much paperwork the lawyers have managed to add to this application. Now, that being said, that editorial comment, I'd ask, and knowing that the applicants have heard the comments and questions of Brenda and Jerry and myself, I'd ask the applicants whether they wish to add anything or ask any questions about the recommended conditions that are on page 3 and 4 of the Mr. Trotman's planning report.
Thanks for that. I guess I would need some really clear direction on what the steps are, because a lot of the language you were using today is legal that means really very little to us. So I don't understand what we're talking about when we're talking about giving a parcel of the front of the land back to the town, because as far as I knew, the land that we're talking about belongs to Lloyd, and we're just transferring it to us. So I just would need some very clear direction on the next steps that we would have to take, because there is already a completed survey that's done. So I'm not sure if I'm being required to do a second survey for the same property.
I will turn that question over to Mr. Trotman. I think it's the same question I was asking.
So the conditions prescribed are standard conditions, and for the layman, yeah, they may seem a little technical. There will be you have your lawyer involved, and you'll have a surveyor involved. You've already had one to do the draft survey.
Yeah, so that draft survey was done 20 years ago. So we have had no communication with that person who did the survey. And actually, we haven't communicated with our lawyers since I submitted the application, because our lawyers were quite clear we didn't need them to do this. So if I need to go back to the lawyers for further details, then I just want to make sure I understand. I don't want to leave today and not have done something properly, so that when we sell 25 years from now, we have the same problem.
No, I don't think that's going to happen. You may have to refresh that draft survey if it is 20 years old, and just ensure, your lawyer will ensure it's sound and accurate for today's purpose. If it's not, a surveyor will have to, I'll use the word, tweak it, and then resubmit as a draft R plan for us to review. Don't get too fussed about condition 4. It's not, what it's saying is that if there's a minor road deviation across a bit of the front, that would have to be conveyed to the town. And we're not talking gobs of land. We're talking what would probably be very minor, but it wouldn't affect the nature of the application.
Right.
Probably condition 4 will probably fall on itself, because there will be no issue there. That's all. It's
and sorry, will we find out about condition 4 when the survey is done then? That's when we'll find out if, okay, understood.
Yeah, the surveyor will say,
could I just comment?
The surveyor will confirm whether condition 4 applies or not. And if it does, it's going to be minor in any event.
I do notice
5, which you might take issue with, common ownership.
Before we go on to that one, David,
that ensures that the severed parcel merges with the with your subject land, and the rest I think are self-explanatory.
I just to draw your attention to Schedule A, which is the 15-year-old survey, and point out to you that that survey already has on it the adjustment to convey, which recognizes the additional setback to the property line. So it may be, just say this for Christine and Andre Walker, that 4 is already dealt with with the survey, and because it's a registered survey, it's 15 years old. It may still suffice and not cause you any additional grief.
So I'm sorry, I started to ask all these questions, but who do I contact to confirm that survey is still of sound, whatever?
So
Who is it that I
if committee
contact
approves-
to do that?
if committee approves your application tonight, there's no reason why they
Right,
might
okay.
not. I will be in touch with respect to how you're going to fulfill those conditions.
Okay, thank you, David. Thank you.
Thank you, David.
I'm sure you remember our stress of finding this out the day we were meant to move, that we couldn't move. So we're eager to fix it, that's for sure.
I surely do.
That being said, are there any comments by any other members of the public who may be in attendance tonight on this matter of application B04-21? Seeing and hearing none, I'd ask whether or not Brenda or Jerry might
I will
propose.
move that it's approved. I will move that it's approved.
Okay, this is a recommendation on page 3 and 4 of the planning report. Do I see a seconder? That might be Brenda.
I will second that with the conditions.
And all in favor? Yes, with the conditions.
Yes.
All of us in favor. Thank you very much. That one is passed. Thank you, Christine Walker, for being here tonight. I see.
Thank you.
Thank you. Thank you for your time.
I see no additional matters on the agenda. Any other business arising? Seeing none, I'll ask for a motion to adjourn. One moment.
All right.
Susan.
Hi. Yeah, I just wanted to, we talked before about potentially setting the meeting for the next meeting at this meeting, the date for it. Do we want to do that tonight?
Which day would you like to propose, Susan?
I think we're looking at the October 28th, the 4th Thursday of the month, right? Am I right on that?
Yes, that is correct. Hearing no objection, it sounds to me like you might have quorum at least. And perhaps you could circulate that date to all members of the committee and see how that lands. 7 p.m. on Thursday, October the 28th.
Yes. Perfect.
Thank you very much. Motion to adjourn.
I
I'll
will.
move.
I'll second it.
Okay. You want to get back to those potatoes, Jerry?
All in favor? Thank you very much for the meeting this evening, and hope we've expedited things in an orderly way.
Thank you, John.
The meeting stands adjourned at 7:30.
Thank you. Good night, everyone.